Hey everyone, welcome back to the channel. Today we'll discuss the topic of inducement of breach of contract. This is a serious issue, especially in business. And if you are a party to a contract or have a business, you need to be aware of this potential legal pitfall. So what exactly is inducement of breach of contract? In simple terms, it's when a third party intentionally causes or persuades one of the parties in the contract to breach the agreement. Now, this is more than just advising someone or giving an opinion. It involves intentional interference with the purpose of causing one party to fail to fulfill their obligations and to breach the contract. In Singapore, inducing a breach of contract is recognized as a tort, and it can lead to substantial civil liability. The law here protects contractual relationships from being tampered with by outsiders. Let's take a look at a couple of real-world scenarios to illustrate how this plays out. Example 1, business rivalry. Imagine two companies, Company A and Company B, competing in the same industry. Company A has a long-term contract with a supplier. Company B wants to gain a competitive edge, so they approach the supplier and offer them a better deal on the condition that they break their contract with Company A. Company B knows that this will result in a breach of contract, but they induce the supplier to do it anyway. Example number 2, poaching key employees. Imagine Company A has a key employee who is under a fixed-term employment contract. Company B, a competitor, knows about this and offers the employee a more lucrative position, despite knowing that the employee's contract has not yet expired. By doing this, Company B is intentionally inducing the employee to breach their current fixed-term employment contract. Now let's move on to the elements of this tort. For someone to successfully claim inducement of breach of contract, several elements need to be established. Number 1, a valid contract must exist between the two parties. Number 2, the third party must know that the contract exists. His knowledge may be inferred from surrounding circumstances and need not relate to the precise terms of the contract. Number 3, the third party must intentionally induce one of the parties to breach the contract. This requirement is most obviously satisfied when A directly persuades B, whether with the promise of reward or incentives or otherwise, to commit the breach. Number 4, the breach of contract must actually occur. Number 5, the claimant must have suffered damage as a result of the breach. The damage can be inferred from the surrounding circumstances. Now let's talk about the remedies available if you find yourself in a situation where your contract has been breached due to the actions of a third party. The most common remedy is to claim damages. You can sue the third party for the financial losses you suffered because of the interference. Another remedy is an injunction. This is a court order that prevents a third party from continuing their interference. For example, you might obtain an injunction to stop the business rival from enticing your key employees to breach their employment contracts. Inducing breach of contract can cause significant disruption to businesses and relationships. If you believe a third party has interfered with one of your contracts, or if you're being accused of such interference, it's crucial to seek legal advice immediately. Remember, proving inducement of breach of contract requires demonstrating intention and actual harm. So always ensure your contractual relationships are solid and clearly documented to avoid any potential legal issues. Thank you for watching. Don't forget to like, share and subscribe for more legal tips. Stay informed, stay protected, and I'll see you in the next video.